Is this on? All right, so I'm Eric Godebois. This is my third or fourth official FaceTime live video. Today is August 3rd. It's around 4:07 on the afternoon Eastern time, and we're going to talk about one of my favorite subjects, and that is trademarks. Okay, so I tell everyone that I'm a business lawyer, and I mean it, but what I really mean is that I can help businesses with most of the things that they do. So one of the most important things is selling stuff or services and making money. So I'm all about your brand. I want you to invest in your brand. I want you to develop your brand. And what I really want is for your brand to become really, really valuable. And someday I'm going to help you sell it. So let's talk about how we protect it from the beginning. So big picture, there are three types of trademarks. I always tell everybody we've got common law trademarks. That just means you're using your brand. You don't need to register it anywhere. You don't need to pay anybody anything. It just is. You are just using your brand in your market. Secondly, we've got the state registration. And every state that I'm aware of has a state-by-state registration. So Florida has one, Delaware has one, New York has one. And that offers some sort of limited protection, and it also brings you under the state's statute. So what that really means is that if you got to sue someone for infringing on your brand, you're going to be using state law. Now the other one, the first one I mentioned, the common law, if you're going to be suing someone for infringing on your brand, you're going to be using what's called the common law, which is kind of like the agreed rules of society that we inherited from the English. And I'll go into it in a second, but you still have the right to sue. Your just protection is a little bit less. And then thirdly, and most importantly, we've got federal trademark law. And so that is a nationwide system of registration. It's handled in Alexandria, Virginia, at the USPTO, the United States Patent and Trademark Office. And that one allows you nationwide protection. And it's not as black and white as it seems. And we could probably go on and teach a class that lasts hours and hours on this subject matter. And today's obviously just a broad overview. So let's go to the board, my favorite thing, and let's just break it down. So number one, you've got common law. Okay, so the common law trademark means that you're using your brand in your marketplace. And so the burden is on you if somebody's infringing on you. So let's just imagine I'm EPGD Law, and somebody else across town in Miami opens up either the same or confusingly similar. And the test, in a nutshell, and I apologize if the wording is not exact, is would an average consumer be confused between the two products? So if I'm EPGD Law, right? And what if somebody else was EGPD Law? Okay, you can see that the only difference is in the middle letters. So under the common law, I would probably start by sending them a letter. It's called a cease and desist letter. And I'd say, hey, stop it. I've had this first, and that's important because you got to prove that you had it first, and you got to prove that you're in the same marketplace. So the burden's on me. I'm going to have to go out and show maybe an example of an advertisement that I used, a copy of my website, maybe the business registration that I did when I created my company, whatever it is that can show that I was from 2013 and you just started in 2015, let's just say. Okay. The other limitation of the common law is that I'm going to bear my own costs. Under the American rule, all litigants, this is people who start lawsuits or are in lawsuits, have to bear their own costs. That's attorney's fees and costs. In fact, the old saying is that attorney's fees are the aberration, not the rule. So aberration typically means a statute, a law, or a contract. So if you and I have a contract, I'm going to have an attorney's fee provision in there. Well, obviously, this guy across town, I don't have an attorney's fee provision with him, so I'm going to have to go under the common law. Now, so let's think about it. I've got to prove that I'm first. I've got to prove that I'm in the same or general marketplace. I got to prove that an average consumer would have been confused, okay? And then I got to pay my own attorney's fees to go after this guy. All right, so that's the common law. The obvious limitations are the burden's on me and the costs are on me. Now, mind you, from day one, I can use the little TM symbol, okay? All that TM is like staking your flag. I always picture that movie, what was it, 1492, where the guy like lands on the sand and he pitches the flag for the nation of Spain. And that's like what it is. He's like staking his claim. So you're staking your claim. You put EPGD Law, you put the little TM right there, and I'm letting people know, hey, I actually have value in my brand, so don't tread on me, as the I guess it's the Tea Party would say. Okay, so number two, we've got the state registration. Okay, state registration, every state has different requirements. I'm going to pay a fee. I'm going to have to give them a proof of, like, usually an advertisement or something that's going to show that I'm actually have been using the mark in commerce. Typically, not only are you going to have to show that you're using it, but you're going to have to show what you're using it for. So let's just say that EGPD Law, my competitor, is actually not a law firm. Let's say that they're selling shoes. Okay? Well, selling shoes does not compete with selling law, so technically we would be in different categories, and presumably an average person would not be confused. Now, the names are so similar, I would still probably try, but I might lose. Honestly, we're not in the same market. Obviously, if it's another law firm, then we're going toe-to-toe. So state registration, they're going to ask you to pick from a list. Now, at the federal level, there are 45 different categories of goods or services, which if you're a big nerd like I